It's Tuesday, April 1st at 11:03. The House Criminal Justice Committee is now in session. Members would, and let's take roll. Mr. Clerk, take the roll.
Mr. Chairman, you have 8 members present. You have a quorum.
Thank you very much. Members, personal orders before we begin. Seeing none, we'll go to our Sergeant of Arms, Mr. Tyler Muniz, for our weekly words of wisdom.
Good morning, everyone. Today's words of wisdom come to you from the next House Employee of the Year, Chase Ingram, the Senior Legislative Advisor. The early bird gets the worm, but the second mouse gets the cheese. Y'all have a great day.
Thank you very much. Anyone else? All right. Item number 2, House Bill 305 will be taken off notice. Item 5, House Bill 689 will be off notice. Item 21, House Bill 1261 off notice. Item 22, House Bill 433 off notice. Item 30, House Bill 1024 off notice. And item 39, House Bill 369 off notice. Brings us to item number 1, House Bill 883 by Chairman Todd. We will roll to the Hill. Item number 3, House Bill 1233 by Representative Gillespie. He is not in the room. We will roll. Leader Lambert.
Mr. Chairman, is this a bill that was going to go to the first calendar of next year?
I believe the representative was going to request that.
Mr. Chairman, that was my understanding as well, and I would make a motion to go to first calendar of next year.
It is properly motioned and seconded. Any objection? Seeing none, House Bill 1233, without objection, rolled to the first calendar of 2026. Item number 4, House Bill 687 by Leader Camper.
Second.
All right. You are recognized.
Thank you, Mr. Chair. Mr. Chairman, I was going to ask you, could I roll this to tomorrow's calendar?
We
to
will
the
roll
Hill
it.
of
We
this
can
kid?
roll it to the Hill.
Can we do that?
I'll, without objection, roll to the Hill.
Thank you, Mr. Chairman.
All right. The next item I have, I've already taken care of that one. Item number 6, House Bill 1082 by Leader Camper. I did. I took that off notice earlier. Yes, ma'am.
For that, working with me on that. Thank you, Mr. Chairman and committee.
I'll give her a second.
House Bill 1082. Mr. Chairman, this bill here aligns Tennessee state law with federal law and empowers state and local law enforcement to prosecute criminals who have used machine gun conversion devices that's already illegal. And so what this does is it's aligning us with federal government in terms of these Glock switches. It empowers local law enforcement to be able to prosecute, and that's what we're trying to do, get these things off the street. We've seen where they've been used, most recently in Shelby County. People have lost their lives because you had an event, somebody have these Glock switches, and they are, shooting and causing devastation on families. I think that's it, Mr. Chairman, what we're trying to do.
Thank you for that explanation. First on my list is Chairman Farmer.
Thank you, Mr. Chair, and Leader Camper, thank you so much for bringing this piece of legislation. I had, as I was reading over it, and then as I was listening to your explanation, I'm currently carrying a bill for Speaker Sexton that's moved through this committee, and it deals with Glock switches, which does make those handguns just like an automatic weapon, and those
Right.
those do not need to be on our streets.
Right.
The bill that I have also deals with ammunition. Felons in possession of ammunition. We're going to add that, line it up with federal law. And then also we're going to make the shooting from vehicles 100% crime there. I know that the drive-by shootings and such is a huge problem. So I just want the members to know and Leader Camper to know that I've got a bill I believe addresses just almost everything your bill attempts to address.
Leader Lambert.
Thank you, Mr. Chairman. And Madam Leader, because we already had a bill that moved through here that covers most of this, I just wanted to know from you, I mean, what would your preference be on this particular bill? I mean, do you want to go to summer study? Do you want to take it off notice, roll it first calendar of next year in case for some reason the chairman chairman's a heck of a fine sponsor. I bet he passes his bill, but at the same time, you never know. Normally we wouldn't pass two through on the same thing. What's the best posture to be able to give you an opportunity that if for some reason something stumbled there to maybe keep this in reserve?
Thank you, Mr. Chairman. Thank you, Leader and Chairman Farmer. Well, what I would recommend is that I sign on to your bill if it's achieving the same goal here, and maybe just take this one off notice. And if we see that, that one does not pass, I'll still have this available to act upon. Either, I know committee will be closed, but I could probably deal with it second calendar or something like that next year. If so, I'm okay with signing on to your bill.
All right.
So just move to take it off notice.
Move to take it off
Yeah.
notice.
Okay.
All right. Any objections? Seeing none, House Bill 1082 by Leader Camper will be off notice.
Thank you, Chairman Committee.
Yes, ma'am. Thank you. Item number 7, House Bill 629 by Representative Hardaway. Oh, Leader Lambert.
Mr. Chairman, I make a motion, items 7 and 8 be rolled to the Hill. I spoke with Representative Hardaway about this.
Okay. Without objection, items 7 and 8 will be rolled to the Hill. Item number 9, House Bill 650 by Representative Parkinson. He is not in the room. We will roll to the Hill. Item number 10, House Bill 167. Representative Mitchell. Roll to the Hill. Item number 11, House Bill 836 by Representative Miller. All right. You are
Members of the
recognized.
committee, House Bill 836, why does this bill make sense? And basically what it's going to do is to legalize marijuana in the state, cannabis. Right now, it's about 29 states that currently legalize marijuana, and it's about 39 states that are legal with medical use. And out of all of those states, the federal government has not intimidated or threatened any one of those states to withhold any federal funds because of the fact that they are legal. But the federal government, it is illegal. Basically, right now, the state of Tennessee is probably number 5 in the country, and for the last 10 years, in the production of marijuana plants in this country. Number 5, think about that. So if we've been number 5 for the last 10 years in the production of marijuana, cannabis, then you should ask yourself the question, who are we selling it to? Because currently we do not regulate it, we really don't control it, and we don't tax it. And for the reason that we don't tax it, we're probably leaving maybe $150 million, I think it's more, annually on the table. Just based on those facts, and these are facts, not what you think, not what you feel, but these are facts. And the facts are a majority of our constituency, that includes your constituency and mine, support both medical as well as recreational. That's a fact. And another fact is that our constituency currently, as of today and every day, are using unregulated, untaxed, and we are not in control of marijuana in this state. It becomes a question of when will we get the message and stop pretending, because our constituencies are not stupid. They understand exactly what's going on with this issue. But the Tennessee House of Representatives, the Tennessee Senate, for some reason, refuse to legalize it. So because of this antiquated law, we're spending more money because it's not legal in the criminal justice system. My next bill is to decriminalize that. But Mr. Chairman, if there are any questions, my plans are to roll both bills until next year, but certainly if there are any questions.
All right, there was a objection to rolling. Is there any questions? Leader Lamberth,
Move previous question.
previous question has been called. Any objection? There is objection. So we will be voting on the objection. All those in favor of previous question, say aye. Aye. Those opposed? The ayes prevail. Previous question prevails. We're now voting to send House Bill 836 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 2 ayes, 7 nays.
The noes prevail. The bill fails. Item number 12, House Bill 981 by Representative Miller.
Thank you, Mr. Chairman, members of the committee. I'm going to take this bill off notice.
Without objection, House Bill 981 will be off notice. Let's go to item number 15, House Bill 599 by Representative Freeman. Roll to the hilt. If y'all are watching this in the office, you need to get down here. House Bill, or item number 16, House Bill 1371 by Representative Chisholm. Roll to the hill. Item 17, House Bill 1372, Representative Chisholm. Roll to the hill. Item number 26, House Bill 1314 by the Chair Lady Littleton. You have a motion and a second. You recognize there's an amendment code 4898. Do you wish to proceed with that amendment?
Yes, Mr. Chairman, I do.
Second.
All right, you recognized on the amendment.
Thank you, Mr. Chairman. As amended, this bill requires the state treasurer to compare the maximum award limit for the criminal injuries compensation program with the national average of the maximum award limit rounded to the nearest 100 each year, beginning with January 1st of 2026 rather than by October of each year.
All right. Does the amendment make the bill?
It does.
Okay. Any objection to adopting amendment code 4898 on the House Bill 314? Seeing none. All those in favor of adopting code 4898 on House Bill 314 say aye.
Aye.
Those opposed? Ayes prevail. You adopt. We're on House Bill 314 as amended. Any questions for the sponsor? Seeing none, questions called. Any objections? Seeing none, we're voting to send House Bill 314 as amended on the full judiciary. All those in favor say aye. Aye. Those opposed? Never mind. Vote on the board. Got in a roll there. Sorry about that. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays, 1 present not voting.
All right, the ayes prevail. House Bill 314 is amended, moves on to full judiciary. Item 27, House Bill 769 by Chair Lady Littleton.
Motion.
You're recognized on the bill. There are no amendments. You may
That's correct.
proceed.
Thank you, Mr. Chairman. This creates an offense for a person to knowingly possess, distribute, or produce technology, software, or digital tools designed for the purpose of creating material that includes a minor engaged in sexual activity or simulated sexual activity that is patently offensive.
Any questions for the sponsor?
Question on bill.
Question's been called. Any objection? Seeing none, we're now voting to send House Bill 769 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays.
The ayes prevail. House Bill 769 moves on to full judiciary. Item 28, House Bill 1352 by Chair Lady Littleton.
Motion.
You're recognized. There's Amendment Code 5267.
That's correct, Mr. Chairman, and it does make the bill.
Okay.
Motion on amendment.
All right. You're recognized on the amendment. The amendment makes the bill. Any objection to adopting Amendment Code 5267 on the House Bill 1352? Seeing none, we're voting. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You adopt or on House Bill 1352 as amended.
Thank you, Mr. Chairman. As amended, this bill requires a person convicted of a Class B felony offense of aggravated sexual battery to be sentenced as a Range 2 offender if the victim was less than 18 years of age or was mentally defective, mentally incapacitated, or physically helpless. It allows the defendant to be sentenced as a Range 3 offender if appropriate.
Any questions for the sponsor? Representative Powell.
Can you speak to the current, how this would either increase or decrease the current penalties?
It does increase.
So a follow-up, so even if the person's a minor or incompetent, it would still increase the penalties?
Could we ask legal, please?
We sure can. We'll
Thank
go
you.
out of session, hear from Legal Services.
Michelle Fogarty, Legal Services. So it's a Class B felony. This would require them, if the victim is less than 18 or mentally incapacitated, to be sentenced as at least a Range 2 offender. So for a Class B felony, a Range 2 offender is 12 to 20 years.
Follow up for legal? Any other questions for legal while we're out of session? Representative Salinas.
So this is if the victim is mentally incapacitated or 18, but doesn't deal with the person committing the crime, correct?
Well, if the person is mentally incapacitated, then they would not be held legally responsible for the crime if they were evaluated and determined to be mentally incompetent.
Okay, thank you.
Any other questions for Legal Services? Seeing none, thank you. We'll go back into session. All right. Any other questions for the sponsor on the bill? Questions called. Any objections? Seeing none, we're voting to send House Bill 1352 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 1352 as amended moves on to full judiciary. Item 29, House Bill 1353 by Chair Lady Littleton. You recognize there's Amendment Code 4512. You wish to proceed with that amendment?
Yes, Mr. Chairman, I do.
Does the amendment make the bill?
It clarifies, but yes, I guess it does.
Okay.
Second.
All right. You're recognized on the amendment.
Thank you, Mr. Chairman. As amended, this clarifies the offense of retaliation for a past action and expands the list of individuals involved in the judicial process to include a former judge, a former law enforcement officer, a former district attorney general, or a former assistant district attorney general, an employee of the judge, a former clerk, a current or former district public defender, a current or former assistant district public defender, and an employee of the district public defender.
Questions for the sponsor on the amendment? Seeing none, we're voting to attach Amendment Code 4512 on the House Bill 1353. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You adopt your bill as amended. Chairlady Littleton.
The amendment made the bill.
Okay. Questions?
Bill. Question on the bill.
Questions been called on the bill? Any objection? Seeing none, we're voting to send House Bill 1353 as amended to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 1353 as amended moves on to full judiciary. And all right, members, let's go from the Hill back to item number 9, House Bill 650, Representative Parkinson. You are recognized.
Thank you, Mr. Chair and committee. Can I roll this to the first calendar of next year? You okay with that?
Leader Lamberth.
Move that this bill go to the first calendar of next year.
All right. Without objection, House Bill 650 moved to first calendar of 2026.
Thank you, Mr. Chair. Thank you, committee. Thank you, leader.
Members, let's go to item 16, House Bill 1371 by Representative Chisholm. You are recognized.
All right. Thank you, Mr. Chairman and committee. This bill aims to update our revenge porn statute. Memphis Police Department, 6 crimes unit. So what the bill does is it clarifies that a person commits the offense regardless of whether the person who distributes the image was a party to the original agreement or the understanding that the image will remain private. So I'm told that in Memphis, a boyfriend gets a new girlfriend and new girlfriend finds photos or videos of the ex girlfriend in the boyfriend's phone or vice versa. And the new girlfriend shares that image. So this puts that third party in the revenge porn statute as well. So with that, I stand for questions.
Questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 1371 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 1371 moves on to full judiciary.
Thank you, Chair.
Item number 17, House Bill 1372 by Representative Chisholm.
Thank you, Chairman and committee. This bill changes.
All right, you're recognized. Yes, sir.
Thank you, Mr. Chairman and committee. This bill changes some of the laws as regards to criminal responsibility. So 2 people go in and commission of a crime, and while there, one person kills the clerk, for example, and both parties get charged with first-degree murder. This would change how that is done. But what I want to do with this bill, I would like to roll this to the first calendar of next year.
Representative Powell.
Motion to move it to the first calendar next year.
There's motion and seconded. Any objection? Seeing none, without objection, House Bill 1372 be rolled to the first calendar 2026. Leader Lamberth.
Mr. Chairman, I will only say this, that I know that that is a a strategic move that sometimes members will utilize, and I don't say this just for Representative Chisholm, but just in general, they will literally be on the first calendar of next year. And so this happens every year. Folks will roll it to the first calendar of next year, and then we will come in the first meeting and kind of, chairman will convene us and full committee chair will be ready. And there's these bills that are sitting there. So I would only ask that if folks do that, let's go ahead and actually be ready to go one way or the other. And we got a lot of time between now and then. So I hope, and I know you will be. So this is more for folks, other people that have rolled theirs. I know Representative Chisholm will be ready, but just kind of a disclaimer out there that, you can take a bill off notice, you can do other things with it, but if it goes first calendar next year, it's supposed to be ready to rock and roll. So thank you, Representative Chisholm. Sorry.
Chairman of the committee.
Thank you. Item 18, House Bill 721. Representative Dixie, you are recognized. There's an amendment code 5968. You wish to proceed with that amendment?
Yes, sir. Yes.
All right, you're recognized on the amendment.
All right, thank you. This bill is to help with some safety for our most vulnerable faculty and staff. This is going to help achieve the level of safety and security for students, for faculty and staff, because they must be protected. The climate within the schools start with those who are tasked with educating the students. Principals, teachers, school secretaries, and others are usually the first points of contact for irate parents. Disagreements in student discipline, grades, student conflicts can lead to parents reacting violently towards schools employees. So many times, adults have contact with school staff at athletic events, school musicals, programs, buses, for instance, and when there's no SRO present, and conflicts can arise. So protection also should extend to these employees from other, as workplace tensions can cause conflict. School bus drivers are the most vulnerable employees as they are unprotected on their bus routes and stops. Many bus drivers have been threatened, assaulted, and injured at stops while picking up and dropping off students. Just recently, a teacher was the victim of an aggravated assault on school property by a person with a weapon. This deterrent is necessary in time for us to protect the learning process. This was only include students who are, not students, adults. This section will say it applies to a person who is enrolled in a school does not apply to a person who's enrolled in a school or a student as a registered participant in the school sponsored activities. So if it's an adult outside the area that's coming in, that's threatening our school buses, sometimes they're waiting at them at bus stops and they're threatening them. The adults are waiting on them because the kids have called them and said, "Mommy, something's happening." And then there's some confrontation. This puts a little bit more teeth into it. And with that, I stand ready for questions.
All right, we're on the amendment code 5968. Are there questions on the amendment? Seeing none, any objection to attaching amendment code 5968 on the House Bill 721? All right, all those in favor say aye. Those opposed? The ayes prevail. You're on House Bill 721 as amended. Was that your explanation?
Yes, sir.
All right, Leader Lambert.
So I didn't want to fight against your amendment. It's obviously what you wanted, but I was looking at the amendment. I was trying to page through here. And is there a logical reason why, I liked your description of the bill, but the amendment guts the bill and says if you're a participant or if you're the words that are used or a registered participant in a school sponsored activity, or if you're a student. So basically everybody, you just said that this is going to protect teachers from their assaults. The amendment just says it doesn't.
No, so I'm glad you asked that question. For clarification, it's for adults. The reason why I put that amendment in there, because I didn't want a student that has a special needs student that may act out or hit someone or just whatever it is through that course of action or what they're doing today. They shouldn't be held to that same standard. My goal is if there's a parent or someone that is not a student or should be registered at that event, and for instance, the example that I use at the school bus, when a parent is waiting for the student to get dropped off and they confront the bus driver, that's the issue that we have seen over and over that's happening in our school systems. That's one of the examples that I'm trying to prevent.
Leader Lambert.
And I agree with that and have supported bills like that in the past, but unfortunately as amended, subsection D specifically says this section does not apply to a person who is enrolled in school as a student, whether they have developmental disabilities or other issues going on or not, just a student, period. If they attack a teacher, this doesn't apply to them. And then, or as a registered participant in a school-sponsored activity. My argument would be, if I was an attorney and representing the person that was charged under your bill, is that they can be charged with anything. Because if they bought a ticket to the event, then they can't be charged. So, Mr. Chairman, it's just not ready. Unfortunately, it doesn't seem like it to me. I would move this to summer study.
As a proper motion, it has been seconded. Any objection on the motion? There is objection. So we'll be voting on all right, we'll be voting on the summer study motion. It will be on the board. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 2 nays.
The ayes prevail. The summer study motion prevails. House Bill 721 as amended will go to summer study.
Thank you, Mr. Chairman and committee.
Item number 19, House Bill 949 by Representative Brooks. You are recognized. There are no amendments.
No.
You're recognized.
Thank you, Mr. Chairman and committee. House Bill 949 is a bill about safely storing firearms. The goal is to find a safer way to keep firearms stored and to make sure that accidental shootings are not happening. After speaking with several members of the committee, I would like to take this off notice and to work on it over the summer.
Representative Powell,
Motion to take off notice.
there's a motion to take it off notice. It has been seconded. It's been seconded. There is objection. So we will be voting. Leader Lamert.
So, Mr. Chairman, I understand the member has come here, gotten a first and a second, spoke on the bill, and if a member wishes to take a bill off notice, there are a dozen members that did that before we started. We have limited time in your committee, and we have asked folks, and I understand that the member is a freshman and is newer here, but you can take your bill off notice before you come to this committee, and we have all of this time burned on a bill, and it's not a ton of time, but it adds up. And so I would really appreciate it if members, if they're going to take your bill off notice, you can give a speech outside. There are lots of ways to be able to make a statement on a bill. It doesn't have to happen in this committee. So, Mr. Chairman, I'm not going to make the motion I was going to make in respect for the member it's her first year in the legislature. But please, 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 if you are listening or monitoring this committee at all and you're a member and you're not going to run your bill, please just let us know it's going to be off notice so you don't take up more committee time. So that's all I'm going to say on the matter.
All right. Representative Powell.
Withdraw, no question.
Okay. All right. There was a motion to take this bill off notice. It was seconded. We had an objection, but that's been withdrawn. So without objection, House Bill 949 will be off notice.
Thank you.
Item number 20, House Bill 1222 by Representative Johnson. You are recognized.
Thank you, Mr. Chair and committee. This bill, no. It's an extreme risk protection order or a red flag law. It's a tool to help prevent gun violence and suicides by temporarily removing firearms from individuals who are in risk or in crisis and in risk of harming themselves or others. This measure aims to protect public safety without infringing on Second Amendment rights. In Tennessee, gun violence is the #1 leading cause of death for our children. As a matter of fact, in Tennessee, we lose 50% more children to gun violence than the national average. A Vanderbilt University poll shows that 75% of Tennesseans support red flag laws to prevent gun violence. This bill will help prevent mass shootings by creating a pause or timeout for individuals experiencing a mental health crisis. Many times, like in the case of Parkland and the Antioch church shooting, we've seen that family or law enforcement knew the shooter was a danger, but had no policy that enabled them to remove firearms. Red flag laws are often supported by law enforcement agencies as a tool to help prevent gun violence and enhance public safety. By allowing for the temporary removal of firearms from individuals in crisis, law enforcement can intervene before a situation escalates into violence. 47% of the time, plans to commit mass shootings are disclosed to others, and 40% of mass shooters legally purchase the firearms they used in the massacre for that purpose. Red flag laws create an opportunity to intervene and remove access to firearms when a mass shooting threat is identified and before the shooting takes place. Who do extreme risk protection orders affect? People who have threatened to commit violence against themselves or others, domestic abusers, and those who are experiencing a mental health crisis to such a degree that the court rules them incompetent. This red flag law includes provisions for due process, such as requiring a court hearing and evidence before a firearm can be temporarily seized, and allowing the person to return to court as often as they want to demonstrate that they are no longer a threat. This ensures that individuals' rights are protected while also allowing for swift action when there's credible evidence of a threat. Overall, red flag laws offer a common sense approach to preventing gun violence and suicides by temporarily removing firearms from individuals who pose a credible threat to themselves or others. By prioritizing public safety, respecting due process, and balancing Second Amendment rights, these laws have garnered bipartisan support and helped to save lives.
Leader Lambert.
Thank you, Mr. Chairman. And for all those who are watching, I had asked in jest, and this is a very serious subject at the beginning, if Representative Johnson was taking this off notice. That's the only reason that she laughed at the beginning. I think some of the members of the committee did. So I wanted to explain that sometimes as legislators, we will have a side conversation that on the camera doesn't show. This is a very serious topic, both to you and to I. My biggest issue with these bills have always been the ex parte nature of them. If we are going to take someone's property under the Fourth Amendment, if we're going to take someone's liberty under the Second Amendment, it should not be an ex parte hearing. It should be an in-person hearing where there is notice and that individual has a right to be able to be there with counsel. So with all due respect, I will oppose the bill, but it is a very serious topic, and I did not want any comment of mine at the beginning to take away from what is a very serious presentation. But that was a side conversation before the bill began. But on the bill itself, that has always been my both legal and philosophical objection to these type of red flag laws. I mean, it takes away someone's property and takes away someone's rights without them even having an opportunity to show up and say, no, this is my side of that. And so the ex parte nature of this will just lead me to be a no on the bill. But thank you for bringing it. It is an extraordinarily serious topic that we should all be focused on how to keep firearms out of the hands of dangerous felons and those individuals that have severe mental health issues, those that are a danger to themselves and others. Those rights have been suspended if someone is, if they're put into involuntarily a mental health institution. And in fact, I voted for a bill, and so a majority of this committee voted for a bill last week that would say even if someone goes into voluntary inpatient treatment for mental health issues, then for a period of time, it would be prohibited for them to have a firearm transferred to them. So I think there's ways to do it without the ex parte nature. Just my opinion.
Yes, and thank you. And yes, I did hear you talk about that. And so that's why I was laughing as well, because joke off of the last conversation. So I hope people do understand that. And I understand about the ex parte, but sometimes the intent is to not attend just so that it can't happen. And that's why the bill does allow for within 30 days that person can come in. And I think the good thing about this bill is also afterwards, say they get therapy, get on medication, whatever, they can come back as often as they would like to see the judge and see about getting their firearms back.
Leader Lambert.
But again, at that juncture, it's already put law enforcement in a position where I'm assuming anyways that if one of these is granted, there's going to be some effort to divest the individual from the firearms. And so the property has been taken at that point. The rights have been taken at that juncture. And it may literally just be on someone else's perspective And I'm not assuming nefarious intent on someone else. I mean, that can happen as well. But even the best intentions of an individual that's reporting someone else, they may just be wrong. And so a simple, allowing that person to be present at that and requiring that person to be present at that, I think remedies that in most of these circumstances where a judge can truly make the decision with the full panoply of facts before them. That's just my issue.
And they are allowed to be present. That I agree with that they should be allowed to be present, but that's there. But if they're not, and it's immediate, there's something that can happen. But I understand your qualms.
Representative Johnson, you had someone signed up to testify today.
Yes.
Do you wish to proceed with that?
Yes.
All right, members, we'll go out of session. I've got two here, Jason Sparks and Carol Buckley Frazier. Okay. Are you Jason? I am. All right, Jason, have your seat right there, if you will. Introduce yourself. For the record, you will have 3 minutes for comments, and then we'll open it up for discussion.
Thank you, Chairman Doggett. Appreciate it. I'm Jason Sparks of Nashville, where I live with my wife and 2 kids who were born here. I'm representing Moms Demand Action, and we support this bill and thank the sponsor for bringing it. In 2021, one of my former employees, Sean Varso, shot and killed his estranged wife, Marie, and his mother-in-law, Debbie Sisko. A month prior to that, Sean strangled Marie and threatened to kill her and her mom. He posted bail, signed an affidavit forfeiting his weapons, but did not, because there's no mechanism to ensure this. Both Marie and Debbie were armed and were gun owners and trained, but that was not enough to save them. Sean ambushed them and took their lives before taking his own life. HB 1222 is an extreme risk protection order law that would give Tennesseans an effective tool to help ensure public safety when a person poses a serious threat to themselves or others. This bill would empower law enforcement officers and close family members who recognize warning signs to petition a court for an order that separates people in crisis from firearms. And if the court finds that that person poses a significant risk of injuring themselves or others with a firearm, that person will be temporarily prohibited from purchasing and possessing guns and require them to turn over the guns while the order is in effect. ERPO laws give a person the opportunity to prevent violence while still containing strong due process protections. The courts involved at every step of the way. 21 states and DC have already enacted these laws. Like all of America, Tennessee is suffering from a gun suicide epidemic. Evidence shows that ERPO laws can prevent those firearms suicides. 54% of all Tennessee gun deaths are suicides. In an average year, 754 Tennesseans end their lives with guns. We've seen ERPO laws save lives in other states. In Connecticut, increased enforcement of their extreme risk law was associated with a 14% reduction in firearms suicide rate. In Indiana, in the 10 years after the state passed its law in 2005, the state's firearms suicide rate decreased by 7.5%. If Tennessee had an ERPO law that was similarly effective, roughly 75 people could be saved on an average every year, including people like Marie and Debbie. We also know that Tennesseans support this legislation. 72% of registered Tennessee voters support a law like this to prevent general gun-related violence. That support isn't limited to Democrats. 69% of non-MAGA Republicans and 50% of MAGA Republicans and 70% of independents polled support these types of laws. It's widely believed that an ERPO might have prevented the shooting at Covenant School in Nashville 2 years ago last week. And according to reports, the shooter was under care for an emotional disorder at the time. After the shooting, the parents of the shooter expressed concerns to police about the shooter having guns. Unfortunately, our state does not provide family members with the tools to prevent the violence that they may fear is coming. So Tennessee must get out in front of our gun violence epidemic.
Well, you hit it right on the nose. 3 minutes. All right. Thank you. Questions, comments for our guest? Seeing none, thank you for being with us today. We'll go back into session. All right. Representative Johnson, you're recognized.
Just would ask that you would vote yes on this bill.
Questions for the sponsor? Seeing none. Any objections to the question? Seeing none, we're voting to send House Bill 1222 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 2 ayes, 7 nays.
The noes prevail. The bill fails. Item number 23, House Bill 1232 by Leader Lambert. You are recognized. There are 2 amendments. I'll give you a moment to.
$4908.
Amendment Code 4908 is the one you wish to proceed with?
Yes, sir, Mr.
All right,
Chairman.
you recognized on the amendment.
Yes, sir, Mr. Chairman. This creates, fentanyl is an absolute killer in our state. This stuff comes in from overseas, comes in from China, comes in from Mexico, comes in from other countries. And it is killing our citizens in large numbers. And a lot of this is being put into other drugs that people do recognize. Many of these folks do use illegal drugs, but they're not ready for what fentanyl brings to the table. It is a killer. And a very small amount of this has killed a very large amount of people. So to try to get a handle on that, this bill would do largely what we did with the meth epidemic almost a decade ago now, which worked. And this would say that if you were convicted of simple possession of fentanyl, carfentanil, remifentanil, all of those, it's a 30-day mandatory minimum. That's what it would carry. It also, on top of that, makes it very, very clear that if for some reason somebody is found with fentanyl, that is an offense that an officer could arrest someone. The goal would be to get them incarcerated into a court setting where they could get help, where they could get treatment. Again, that's what we did with the folks that were on meth a decade ago. It worked very well in Sumner County and throughout this state, and still works to this day to try to get folks in a bed somewhere to get them treatment. It's not just about getting them in jail. It's about getting them into treatment. And then the last part of this deals with if someone overdoses on fentanyl. Every single one of those cases, thanks to Chairman Littleton's leadership on some bills in the past, those cases are a potential homicide case. Every single one of those, if they're drug dealers or a drug dealer out there that's selling this stuff to someone and then they overdose on it, that is a potential homicide case, and the scene should be treated as such. And that's what the last aspect of this does, Mr. Chairman.
Thank you very much. Question's been called on the amendment. Any objections? Seeing none, we're voting to adopt Amendment Code 4908 onto House Bill 1232. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You adopt on your bill as amended. Representative Powell.
A question for the sponsor. So let's say somebody was found in possession of a drug that had been illegal, but it was been laced with fentanyl and they weren't aware of that, which unfortunately, obviously somebody shouldn't have drugs, but also the fact that they might not know that what they had was laced with fentanyl. Could you speak to that? Because what I hate to do is, increase the penalties on somebody who had no even awareness and that they had that fentanyl on them.
So, thank you, Mr. Chairman. This only goes into effect if the person is convicted and goes before the judge for sentencing. If there's an agreement worked out with the state beforehand, or if the officer obviously can utilize their discretion on not even charging in that type of circumstance. That's handled through the investigatory process. Now, possession of fentanyl is possession of fentanyl, so that's illegal now. Really what this deals with is the ability for an officer to be able to arrest someone that is clearly in possession of fentanyl. And if convicted, they would face a 30-day mandatory minimum. And that's critical if convicted. Every single person that's arrested is innocent until proven guilty. And having something that you believe to be a lawful prescription is certainly a good defense in any type of possession case. The only way you would have a lawful prescription, well, I don't know of a way you could have a lawful prescription that had fentanyl within it. It's simply not in a lawful prescription. You would have to be buying pills out on the black market from a drug dealer that had been fashioned to look like a lawful prescription, but there's no way to go to a pharmacy and get something that would run afoul of this law.
And I understand that, but I've heard circumstances where people have gotten, drugs from others and they assumed it was something and it was then laced with fentanyl. So I guess back to my question, but you're saying that you think that there's discretion with the judge and others, where if something looks like it's clearly, let's say ecstasy, I don't know, just throw out a drug and it had been somehow laced with fentanyl, even though it's not a prescription drug, I get the point. But some situation like that, there would be leniency given that would be considered is your intent?
Absolutely. Again, both the officer and the district attorney can take all of those issues into account well before it ever gets to a judge. The 30-day mandatory minimum is only if someone has either pled guilty or been found guilty, and then that's a 30-day mandatory minimum, which is a starting place. Now, I will tell you, when the meth epidemic was in its absolute kind of worst state, and it's still a bad situation out there. But when you and I were serving down here and some other members of this committee, and you had homes and everything that were blowing up from them cooking meth, many of those folks got 1129 to serve. And usually the judge would pull them out after a couple of months and say, look, are you clean? Are you sober? Are you ready to go to treatment? And then they would send folks off to a lengthy inpatient treatment, which is the goal of this. So if somebody just inadvertently has, again, some sort of any kind of pill that has this in it, they had no idea. I mean, that's a heck of a defense to something like this in court.
Any other questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 1232 as amended to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 nays, 2 present not voting.
The ayes prevail. House Bill 1232 as amended will go on to full judiciary. Members, real quick, we'll go back to item number 1, House Bill 883 by Chairman Todd. Just received word he would be taking this bill off notice. So item 1, House Bill 883 will be off notice. Now we'll go back to item 24, House Bill 1343 by Leader Lambert. All right, you recognize no amendments.
Thank you, Mr. Chairman. This just deals with the EMIF fund that we have had for several years. Unfortunately, it has not been able to keep up with the demand that is needed. This comes directly from the treasurer, and we just structure a little bit better on how folks are determined to be indigent.
Questions for the sponsor? Questions called. Any objections? Seeing none, we're voting to send House Bill 1343 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 1343 moves on to full judiciary. Item number 25, House Bill 486 by Chairman Farmer. You recognize there's Amendment Code 5357. You wish to proceed?
Yes, Mr. Chair.
You're recognized on the amendment.
Thanks so much. The amendment reroutes the bill. It's just asked that it creates 5 additional assistant district public defender positions, members.
All right. Any questions on the amendment? Seeing none, we're voting to adopt Amendment Code 5357 on House Bill 486. Those in favor say aye. Aye. Those opposed, ayes prevail. You adopt. We're on your bill as amended. Any questions for the sponsor? Seeing none. Objection to the question. Seeing none, we're voting to send House Bill 486 as amended to full judiciary. Any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 486 as amended moves on to full judiciary. Item number 31, House Bill 1027 by Chairman Russell. You recognize there's Amendment Code 5472. You wish to proceed with that amendment?
Yes, Mr. Chairman.
All right, you're recognized on the amendment.
Thank you, Mr. Chairman. The amendment makes the bill, if I can get that added.
All right. We will, any objection to the question on the amendment? Seeing none, we're voting to attach Amendment Code 5472 on the House Bill 1027. Those in favor say aye.
Aye.
Those opposed, ayes prevail. You adopt your own, the bill as amended. You're recognized.
Thank you, Mr. Chairman. Committee, House Bill 1027 creates the Tennessee Victims Act, which seeks to create a grant program for law enforcement agencies to improve their clearance rates and the district attorney's office to improve their case closure rates by providing swifter justice to criminals, more expedient relief for victims, and a better public safety outcomes for all Tennesseans. And just a side note, the Senate approved this unanimously in their committee, and they can't agree on where to have lunch.
Second.
Question has been called. Any objection? Seeing none, we're voting to send House Bill 1027 as amended to full judiciary. Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
All right, the ayes prevail. House Bill 1027 as amended moves on to full judiciary. Item 32, House Bill 370. Representative Scarborough, you are recognized.
Thank you, Mr. Chairman. House Bill 370 just adds some language to the current law. It adds in person the definition of harassment by communication. Currently, communication is defined only by means such as writing or by telephone, text, or flyers. This addition in language will help provide the tools necessary to district attorneys and law enforcement to hold individuals accountable for hate crimes. With that, sir, I'll take any questions.
Questions for the sponsor? Question's been called. Any objection? Seeing none, we're voting to send House Bill 370 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays.
The ayes prevail. House Bill 370 moves on to full judiciary. Item number 33, House Bill 371 by Representative Scarborough. You are recognized. There's Amendment Code 4195. Do you wish to proceed with that amendment?
I do, sir.
All right. You're recognized on the amendment.
This bill as amended would require anyone convicted of a Class A misdemeanor to complete a cognitive behavioral training course. Studies have shown that recidivism rates have lowered when individuals take this course. Many counties have already owned cognitive behavioral training courses, and they continue to still use those courses under this bill. With that explanation, I'd ask for your vote. That's sir. I'll take any questions.
All right. Very good. Questions for the sponsor on the amendment? Seeing question on the amendment has been called. Objection. Seeing none, we're voting to adopt Amendment Code 4195 on the House Bill 371. Those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt your bill as amended. Did that explanation make the bill?
I remove my motion.
All right. Questions for the sponsor? Question's been called. Any objection? Seeing none, we're voting to send House Bill 371 as amended to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 371 as amended moves on to full judiciary. Item number 34, House Bill 527 by Representative Scarborough. You are recognized.
Thank you, Chairman. Good afternoon. I'm here today to present 527 on behalf of the District Attorney's Conference. As currently written, parole can be denied if the parole board determines that releasing an inmate would undermine the seriousness of the crime or promote disrespect for the law. However, this cannot be the sole basis for denying the parole unless the inmate is serving a sentence for one of the 22 listed offenses currently. This bill will actually bring all felonies under consideration under the same status and again, eliminate the consideration mitigating factors. For that, sir, I'll stand by.
Thank you for that thorough explanation. Leader Lambert.
Mr. Chairman, I was just curious. I mean, the member here is a freshman and hadn't even passed a bill on the House floor yet and has 1, 2, 3, 4, 5 bills on your calendar that I'm counting here. He only gets 12 for the year. I just wanted to remind him he's young and he just got here. You can run bills earlier in the year. It's okay. I mean, I saw you walking around with your trapper keepers earlier today. For those under 30, that's the thing that you would use in school. But I just want to remind him he can run his bills earlier if he wants to. So, Mr. Chairman, that's all. Looks like a good bill, though.
Representative Scarborough.
I already did my motion.
All right.
Well done. Question on the
Question's been called. Any objection? Seeing none, we're voting to send House Bill 527 on to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 nays, 2 present not voting.
The ayes prevail. House Bill 527 moves on to full judiciary. Item 35, House Bill 671 by Representative Scarborough. There is an amendment code 4524. All right, first I need a motion and a second on the bill. I'm sorry, I jumped ahead of myself. All right, you recognize on the bill, there's an amendment code 4524. Is that one you wish to proceed with?
Yes, sir. Makes the bill. Second.
All right, you recognize on the amendment.
This bill introduces procedural safeguards and accountability measures for the bail bondsman, while also providing him a clear pathway for release from any obligations that demonstrates good faith efforts to locate a missing defendant, ensures that bondsmen are fully informed of bond conditions before accepting bail and deposit, increasing compliance and due diligence in the bail process.
Any questions for the sponsor on the amendment?
Question on the amendment.
Question's been called on the amendment. Any objection? We're now voting to adopt Amendment Code 4524 on the House Bill 671. Those in favor say aye.
Aye.
Those opposed? Ayes prevail. You adopt. We're on House Bill 671 as amended. Representative Scarborough.
Mr. Chairman, I renew my motion. I stand by for questions.
All right. Any questions for the sponsor? Withdrawn. Leader Lambert.
So I know there's several bail bonds bills going around this year. What I've read through the amendment and I was just looking it over to make sure I was looking at the most recent version and everything. What's the purpose of what we're doing here? Like why are you bringing the bill? What would it accomplish?
Yes, sir. Chairman, the purpose of this bill is to try to create some constructive, solid procedural efforts in order to release bail bondsmen from consideration of their obligations. That's why I renew my motion.
Yes, sir.
Is it, I mean, so the judges now will already have a hearing. They'll determine, in their mind as the elected local judge on why someone should be released or not. Is that not enough? I'm trying to just figure out like, why are we putting guardrails on this? And at least in my county, it seems like my judges do a good job of this. And I'm just trying to figure out the reason why we're doing some additional here.
Yes, sir.
Chairman and members, I think I'm sure your area does that, and I'm sure a lot of areas across the state does. But this one's sure that all across the state will have the same, will consider the same obligations, and courts will continue to evaluate the specific factors you're talking about.
I will say we do have some here to testify today, so without objection, we'll go out of session. I have on my list Jimmy Music, Steve Crump, Mike Donovan, and Ms. Courtney Lynch. So I take it Ms. Lynch has declined to testify today. Okay. All right, gentlemen, you're familiar with the process. If you will, introduce yourself for the record. You'll have 3 minutes for comments, and then we will open it up for discussion.
Good afternoon. It's 6 after 12. So Jimmy Music representing the Sheriff Association, Tennessee Association of Chiefs of Police. This was something that we worked with the DAs over the summer when we were trying to figure out what exactly we thought that there were any gaps or issues. One that was identified was the lack of notice to both the prosecutors and especially the sheriff of a bonding agent coming off the bond. We were trying to create a process that was fair, that didn't change too much, but ensured that notice happened. I'm not aware of a lot of places having an actual full-blown hearing for these. Oftentimes what we were made aware of was things happening, either in judges' chambers or coming out after a docket, et cetera. And so not trying to imply that there's any funny business going on there, but our preference is that this be done in a hearing where there is a showing of good faith efforts to procure the appearance of the defendant in court.
Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference. As both an assistant DA and then later as an elected DA, it was very common practice both in areas where I served in the 10th Judicial District, but also around the state for many of these hearings, particularly in General Sessions Court, to not occur, period. What would happen is the bondsman would come in after the docket had been concluded and the DAs had gone home for the day, as everybody else had, and they would approach the judge, frankly, in an ex parte manner, and would be relieved from their bonding obligations. And nobody had any opportunity to object or to explore what they knew about a case or defendant's whereabouts. Again, as Mr. Music said, certainly not suggesting that there was anything improper in any of that. And many of those, frankly, the state may have agreed to. But there were a number of times where we lost track of defendants in very significant cases simply because we were never afforded the opportunity to even be made aware that the bondsmen were coming off the bond. We next learned that the bonding company had come off the bond when they failed to appear for the next court appearance.
Mike Donovan, Deputy Executive Director, Tennessee District Attorneys General Conference. I agree with Director Crump. I previously served as an elected DA in West Tennessee, and so this is not unique to East Tennessee or the 10th District or any other district. Many times those proceedings were either done ex parte or, again, without the knowledge or the opportunity to be heard by the state. And so we think that this brings a proper balance of due process in open court where there are actual factual findings that are made by the judge and reduced to writing. So thank you.
Thank you. Questions for our guest? Seeing none. Thank y'all for being with us. We're back in session. We're back on the bill as amended. Representative Scarborough.
I renew my motion.
You renew your motion.
Question on the bill.
Questions called. Any objection? Seeing none, we're voting to send House Bill 671 as amended to full judiciary. Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 nays, 1 present not voting.
The ayes prevail. House Bill 671 as amended moves on to full judiciary. Item number 36, House Bill 1268. All right, item number 36, House Bill 1268 will be off notice. Item 37, House Bill 1292, Representative Powell will be off notice. Item 38, House Bill 1295 by Representative Powell. All right. We will roll House Bill 38, House Bill 1295, first calendar 2026. Members, we're going to take a 5-minute recess. All right, members, we're going to go back into session. And we have a few items to take care of before we get to our next bill. Item number 4, House Bill 687 by Leader Camper will be rolled to the second calendar of 2026. Thank you. Yes, ma'am. Item number 8, House Bill 1064. We'll address that one in a little while. Item number 10, House Bill 167 by Representative Mitchell will be off notice. We'll go ahead and do item number 8, House Bill 1064 by Representative Hardaway will be off notice. Item 13, House Bill 931 by Representative Towns, first calendar 26. Item 14, 1098, Representative Towns, first calendar 26. Item 15, House Bill 599, Representative Freeman, first calendar 26. Brings us to item number 7, House Bill 629 by Representative Hardaway. You are recognized. You have an amendment code 4485. Is that one that you wish to proceed with?
That's correct, Chairman.
You are recognized on the amendment.
Thank you, Chairman. The amendment rewrites the bill. It authorizes juvenile court to order a child who is accused of being delinquent or unruly and has been released prior to a hearing to wear a GPS global positioning monitoring system device. Requires the entity operating the GPS system to notify the probation officer or other entity ordered to take charge of the child if the child violates the instructions issued by the court upon release. It requires students who are adjudicated delinquent for committing the offense of threatening mass violence on school property or a school-related activity to undergo counseling and a mental health evaluation. With that, Mr. Chairman, I would ask for adoption of the amendment.
All right, questions for the sponsor on the amendment? Seeing none, any objection to the question? Seeing none, we're voting to adopt amendment code 4485 on the House Bill 629. All those in favor say aye. Those opposed? Ayes prevail. You adopt or on your bill as amended. You said the amendment didn't make the bill?
It rewrites the bill, sir.
All right. We do have testimony on the bill here. So we will go out of session. Ms. Kristen Veloff and a Hayes O'Donnell, who says no thank you. If you would introduce yourself for the record, you will have 3 minutes for comments and we'll open it up for discussion.
Thank you, Chairman and committee members. Kristen Veloff with the Department of Mental Health and Substance Abuse Services. We are here today to discuss some concerns regarding how the bill is mandating the crisis evaluations underneath Section 2 of the amendment. Currently,